Mr. Singh?
Good morning, Judge. Good morning, Your Honors. May it please the Court? Your Honors, my name is Cheyenne Elahi. I represent the appellant Heritage Pacific Financial today, and I will reserve 5 minutes for rebuttal. Your Honors, I am here on a case originating in 12th Circuit.
I don't want to interrupt. Are you associated with Ramona Singh?
She is also an attorney for Heritage Pacific. I am on the record, sir, as a co-counsel.
Okay. You have a notice, okay.
Yes, sir, I do.
Okay,
Thank you. Your Honors, this originated out of 12th Circuit in Sarasota. Heritage Pacific Financial had brought a suit against Mr. Andrew Lane and Anchor Appraisal on professional negligence, 3 counts of professional negligence. Negligent misrepresentation, and also negligent misrepresentation for the guidance of others. There was along with the complaint, the appellant had filed the note, the allonge, and the assignment. This is the chain of ownership that we established and that we had informed the court of. The original note was owned by National City Bank, which was transferred to DBI funds out of New York, which was then transferred to HP Debt Exchange, LLC, which was then transferred to Heritage Pacific Financial. Now, we had...
You skipped a step there. I mean, the sale from DBI to HP Debt Exchange was apparently in February of 2010.
Yes, sir.
The lawsuits filed in July of 2012.
Yes, sir.
And then the assignment from HP Debt Exchange to Heritage Pacific Financial doesn't take place until November of 2012.
Sure, we can see
Correct?
that. Yes, sir, it is correct. Now,
that's 4 months after the complaint was filed.
Sure, but the reason we're here is not necessarily, and that's a point that we can discuss. But, Your Honors, we're here because the motion for summary judgment was granted. And what I would like to argue today is that if this ruling is allowed to stand, it would dramatically change the standard in Florida for granting motion for summary judgment.
Who hired the appraiser?
It was originally hired by Mr. Scott Dyer, who was obviously the owner of the property at that point.
The owner hired the appraiser for purposes of obtaining a mortgage.
Yes, sir.
And you're not that mortgage company.
No, sir, but we own the note.
You're a second or third buyer.
Sure. In the secondary purchasing market.
If you were worried about the appraisal when you bought it, why didn't you get your own appraisal?
Well, so the way it works is, first of all, it's a very common practice in the market to sell a note to another and then to another.
Is there any case law that says that you're not in privity with this appraiser, you didn't pay for this appraisal? What law creates a duty upon the part of the appraiser to protect your client as compared to the people who actually paid for his services?
The Article 23 of the appraisal agreement itself creates that duty. And the appraisal certifies in Article 23 of their own agreement that they understand that this appraisal can be used for any subsequent purchaser or in the secondary market by any purchaser. So they very well understand this is a customary thing in the real estate market. They know that when they're making an estimation on a property, it will be relied upon by others and others and others. Specifically, just as in this case, Your Honors, we're talking about the appraisal company appraised this property for $1.3 million. They had to take a $750,000 loan, and then Mr. Dyer, and then had to get $350,000 loan from a second mortgager, which is the note we own. But if I may continue and bring this back to the very idea of not necessarily just the merits of the case, this case was cut short because the trial court erred in granting the motion for summary judgment because not only we had provided more than enough evidence that we were the holder of the note, the statute itself, if I may continue stating that, says that the owner of the note, and I'm referring to, if I may, Your Honors, the Florida statute, may I just say? Your Florida statute, I'm on the record, 673.3011, clearly states the holder of the instrument has the right to personally enforce all the rights that go with the note. Your Honor, we attached that note, the appellant attached that note to the complaint with an allonge, and an assignment was provided to the judge.
One of the questions, though,
Yes, sir.
and that was the basis for the trial court's ruling, was whether a separate tort action actually gets transferred along with the note.
Sure, and that's exactly why we're here. If that was the question, then that question should have been asked. It was never asked in trial court. What was basically if you review the judgment, the 3-page judgment that comes out of trial court, it essentially relies on the Ginsburg case, and it argues that we did not provide sufficient evidence that we had that right transferred from the original note holder, which was City National Bank.
Right. You got an assignment of their contractual rights under the promissory note and mortgage, but is that effective to give you an assignment of their tort rights against third parties? I guess.
It is, because
Is there a case similar to this that so holds in Florida or elsewhere?
Your Honor, there's no case that holds this or otherwise, because the other side did not provide any case to the contrary either at the motion for summary judgment. And again, this is about the standard for motion for summary judgment. If we were to move...
This is a case of first impression anywhere in the United States?
Judge, I wasn't able to find anything that stood for a proposition, because it's a fundamentally understood proposition in the real estate market that the mortgage follows the note. Now, the mortgage was based on...
I understand the mortgage follows the note.
Right.
What I don't understand is whether the tort claims or the professional negligence claims of the original people retaining the appraiser would also follow the note. That's what I'm not so sure about.
Yes, sir. Because the mortgage relies upon the appraisal, and the appraisal Article 23 clearly states that they understand that this is being relied upon to get the mortgage, that attaches, and that goes with the note. All the fundamental rights,
So is
which are...
there allegations and evidence that your client reviewed the appraisal and relied upon the appraisal when they purchased this note?
Your Honor, because we own the original note, which was relied upon to give that $350,000 to Mr. Dyer, and when the property was foreclosed upon, there was a 500 plus something and changed deficiency.
Maybe Mr. Dyer wants to sue on his own tort claim.
Well, Mr. Dyer has given us the allonge. He has sold that note to us. We have the allonge that we attach to the complaint.
The question of, does that mean he's transferred and assigned his tort claims as compared to his contractual rights?
Yes, sir.
Is there a case that says that you transfer your tort claims when you transfer your contract claims?
Your Honor, again, I would state that it's such a fundamental understood assignment of rights, and if that is curtailed, then people will stop buying property, and will basically, all sort of litigation will cease. But again, Your Honors, what I would suggest is that if...
This will end commerce as we know it. Why isn't there a case someplace where this has ever been discussed?
This may not end commerce as we know it, but it will end the motion of summary judgment as we know it. Because we exceeded that. But, Your Honor, I have 3 cases from 2nd DCA, which establishes very clearly that the standard is that if there's even the slightest doubt as to the existence of dispute of material fact, then a judgment granted must be overturned.
It seems to me that this is a pure issue of law, which is whether or not an assignment of a note and mortgage by allonge also assigns any professional negligence or tort claims that the original parties may have vis-a-vis their lawyers, their appraisers, and the other people that were involved in the initial closing on the note and mortgage.
Your Honor, then essentially we're saying that any appraiser can appraise any property for any amount and not be responsible for anyone else but that one person who did it for, and Article 23 in the appraisal contract means nothing. And that will just negate all the Article 23 if we uphold this ruling, plus we will destroy the MSJ as we know it. And again, I go back to...
Let me go back to my question then on 23. Did you allege that your client actually reviewed the appraisal and relied on the appraisal when they purchased the note?
Your Honor, we allege that we...
Yes or no, probably.
Your Honor, if it was that simple, I would answer it.
Okay.
But because in the secondary purchasing market, which exists legally in our capitalist system, we operate under the assumption that if I sell you a right, I'm selling you the right to sue on my behalf, then you can go forth. Mr. Scott Dyer's allonge to Heritage Pacific specifically is for that reason. Otherwise, what's the purpose of that? What is the purpose of the allonge? Mr. Scott Dyer did not want to sue the appraiser. He couldn't afford to. He got foreclosed out. He lost a house. He was a victim of the appraiser. We can sue the appraiser because we are a company and we can afford that. We bought the loan and we can go after the appraiser if we wish to. And Judge, there is a real concern here, a public policy concern, that if we let this stand, we can let all the appraisers go scot-free. Secondly, we may deviate from our standard motion of summary judgment. If you may allow me 2
Is it your
seconds.
standard position never to get a deficiency judgment against the original borrower?
I apologize, Judge.
Do you never get deficiency judgments against the original buyer when you go through foreclosures on these?
Original borrowers, Judge?
Right.
Meaning the consumer?
Right.
No, Judge, we're going after the appraisers. We have sued the appraiser here.
You waive all your, what I'm pointing out is the person who is actually harmed is the person with a deficiency judgment against them because they originally got into this deal not understanding what the house was worth, right?
Yes, Mr. Dyer in this case.
So he's the one that should be suing someone for negligent, professional negligence or fraud in the inducement or some theory, not you.
But Judge, like I said, again, the problem is he's one person. He's not in that position. Judge, the government bought a lot of these.
If you want his rights to do that, why don't you go get an assignment from him if he doesn't want
Judge, we got the allonge. We did. It's attached to the complaint, Judge. That's what we're saying. And the trial judge essentially says there's nothing there. The other side says there's nothing
The
there.
consumer that has the deficiency judgment sue the appraiser.
Did he?
Can he?
Of course he can.
Okay. So if he can do that, even when his note's been assigned to other people, how did you get his rights?
No, at this point he can't. He could have. Yes, Judge, I apologize. I misspoke. He could have, of course.
Until the lender assigned the note, or what?
Yeah, if he assigns his rights, then obviously he allows someone else to act on his behalf. So he could have sued them, even initially he could have. Just like I said, many consumers, victims of the foreclosure, and victims of fraudulent appraisers.
When did the consumer assign his rights?
Judge, it's attached to the complaint, it's an allonge, I can look up the date.
No. There's a homeowner here someplace.
Yes, Mr. Dyer.
And he's the fellow who paid for the appraisal, right?
Oh, well, Judge, the way it works is I think the realtor, and I mean, it's a big market, I don't know who paid for it essentially.
He's one of the people who...
Sure, yes,
Okay?
yes.
And so, when did that man assign to you anything?
There's an allonge attached to our
The
complaint.
allonge came to you from the lender.
No, sir. Allonge is directly from Mr. Dyer to Heritage Pacific Financial. It's attached to the complaint. The trial court erred when they did not look at that, and they deviated from the standard, which says, again, Judge, we're just talking about the summary motion judgment here. We're not talking about, we could go to trial and lose. We could go to trial and win. We're talking about whether a motion for summary judgment can be granted when so much documentation.
A allonge from a homeowner.
It's attached to the complaint, Judge.
How does that work? How does the homeowner assign a note and mortgage documents? I don't understand that.
Judge, essentially he signs an allonge. I mean, it's a paperwork we provide, or
Which would come from the lender, wouldn't it?
Judge, the note comes from the lender because Mr. Dyer, I apologize, was a purchaser. We got the allonge from him as well. It's specifically that because we are covering obviously all the bases. We want to make sure we litigate properly. We want to make sure we come in front of you to try to get you as much chain of custody possible.
You get an allonge from both the original lender and the original borrower.
Judge, usually companies assign things to each other.
I'll tell you, I've seen a gazillion foreclosures in the last couple of years, and I've never seen nor noticed an allonge from the original borrower.
Judge, I am here arguing because in the complaint, I'm stating this because in the complaint it's attached.
Here, I'm going to see an allonge from the borrower and not from the lender.
Judge, we have assignments from the lender. We have an agreement with the lender. Again, City National Bank is out.
Tell us where we find the assignment from the homeowner. What page of the record?
Judge, I have the allonge. It's attached to the complaint. I believe it's Exhibit B.
Okay.
And I have it open here if you want me to let you know what the date is. Judge, it's attached to the original complaint that was filed, our original pleadings. So, and it's signed, it's bar Mr. Dyer, it is, and it has a property address, and it is given specifically to Heritage Pacific Financial, Judge.
From whom?
It says, Mr. Okay. I do apologize. I might have misspoken on this issue. I think the allonge is to the promissory note from DBI.
Okay.
I do apologize.
You're down to 5 minutes, by the way.
Okay. Down 5 minutes, Judge?
Before you sit down, we've got a pending motion for attorney's fees from the appellee under 57105. Do you want to address that?
Judge, if you remand and overturn this MSJ, then we believe that the attorney's fee issue goes away because we had a good faith pleading.
Let's suppose, hypothetically speaking, and we haven't made up our minds or made a decision, but hypothetically speaking, if we affirm, then we'd have to address the motion for attorney's fees that the appellee has filed, and I just wonder if you want to address that.
No, Judge. If obviously we let this stand, then we are stuck with that ruling. But Judge, when I come back for 5 minutes, I don't know if I have any time left right now, but I want to address specifically the standard for the motion summary judgment and that the second DCA has established and accepted, and also the fact that there are other case law out there that requires an actual evidentiary hearing if there's an issue as to whether the suing party has standing or not on a foreclosure matter or a note. So I can do that in the next 5 minutes that remains.
You can argue anything in rebuttal in the next 5 minutes. So it's down to 4 minutes too. So okay.
Am I out of time, Judge?
No, you've got 4 minutes left.
Oh, I do have 4 minutes. I apologize. Okay, Judge.
Well, 4 minutes out of your 20.
That's fine, Judge.
Okay.
Let me just get back to just the standard for motion for summary judgment. Your Honors, it's well established that if the standard for review is obviously de novo, and when reviewing the summary judgment, the appellate court must examine the record of the light most favorable to the non-moving party. I don't have to educate you on this. I understand that, Judge. Here, we have provided the documentation with the pleadings and the assignment. Judge, even if there was any doubt, it has to be inferred and it has to be towards the plaintiff and the non-moving party, rather, which was us. So the trial court erred in applying that motion, standard, or deviating from that standard. So just for the very fact, I think we should be allowed to proceed with our litigation, and everything else can come in discovery. I believe I have 2 minutes left. I'll keep it for rebuttal.
Okay.
Great. Thank you.
Thank you.
May it please the Court, Matthew Belcastro on behalf of Appellees, Andrew Lane, and Anchor Appraisals. Your Honor, the first issue I'd like to address relates to the question about the legal authority pertaining to the assignment involved in this case. And now, it sounds to me like you're on top of the issue that we raised in our brief here, which is that we've got a downstream party who purports to have acquired rights under a note, trying to circle back and sue someone in tort that was involved in connection with the transaction that gave rise to the loan documents. So we've got someone who's far along in the process looking to circle back with respect to the creation of the documents. And I'm not aware of any legal authority that allows them to do that without a separate assignment of claims as opposed to assignment of a document.
What about this paragraph 3 where maybe your client gave them the right to rely?
I believe it's paragraph 23, Your Honor, and the language of that paragraph in connection with the appraisal says that, I'm going to paraphrase, but an assignee can rely upon this appraisal in connection with a mortgage finance transaction. Okay, a mortgage finance transaction. That's not what we've got here in terms of how the appellant acquired the note. They bought a bundle of loans from somebody. They weren't acquiring or giving a loan for purposes of getting a mortgage back.
So a transfer of a note and mortgage is not a mortgage finance transaction?
I would argue that the purchase of a bundle of loans is not. That the mortgage finance transaction is the transaction in which this lender advances funds in exchange for a mortgage which is secured by this piece of property. That is a mortgage finance transaction in my mind. Otherwise, we're dealing with sales of negotiable instruments.
Is there any case law that, is this a standard paragraph that appraisers use, that there might be case law?
Well, you know, it's pretty standard now. There is a case, not cited in our materials, Your Honor, and I hate to go off brief, but I think it's Cooper versus Bracura, which is a negligent misrepresentation case that talks about whether or not a party can sue in misrepresentation. And basically, the essence of the case, I'm going to paraphrase, it says...
If you haven't cited it and your opponent does not know about it, why don't you just give it to us in a supplemental authority after a while?
Fair enough. So where we are, Your Honor, is, in my mind, there seems to be some confusion about whether or not the appellant, the plaintiff below, is suing in his own capacity. In other words, is he saying he relied upon something? Because if that's what he's saying, that would seem to be what would kick in this paragraph 23 here. But if he is saying he relied upon something in this appraisal report, that argument is completely belied by the fact that they've attached a field review report to their complaint which says, I apologize, I forget the numbers, Your Honors, but it says that the property is worth X dollars, whereas our appraiser said it was worth Y dollars. So how can they conceivably have relied upon our appraisal when the document attached to their lawsuit says it's worth less money?
Well,
and they admit...
a deal also where they bought, I don't know, a very large number of loans. I don't know whether maybe they were already in default, but they bought just a huge number of loans from the transferor, didn't they?
Well, again, you know, I'm not entirely clear about that. They did attach a mortgage loan sales agreement in connection with discovery requests and responses, but that wasn't their transaction. That was one of their predecessors. So when we filed our motion for summary judgment, you know, the essence of our motion for summary judgment was, look, Your Honor, we have an assignment document, this mortgage loan sales agreement that purports to be between two parties that aren't part of this litigation, and all it does is transfer a note. Okay, it transfers a note and mortgage. It doesn't transfer tort claims. So you can't sue in tort when you don't have an assignment of a tort claim. And Judge Altenburn was asking before about whether there's a case on this. And I think there is. It's cited in our brief. It's a case of Ginsburg versus Lennar Florida Holdings. And in terms of the relationship of the parties, it's very similar to what we have here. We've got the downstream holder of a note circling back and suing in tort for some actions that occurred in connection with the original transaction. It's not an appraiser. It's a complicated underlying transaction that has to deal with withholding of rents. So it is nonetheless very similar to ours in the sense that the holder, the downstream holder, is trying to circle back and sue one of the original parties in a tort claim. And I'm going to read to you what the court says about this, because the rationale is exactly the same as what we've argued here, which is that an assignment of a note does not give rise to an assignment of tort claim. It's not the same thing. The court says, the assignment of mortgage is, as it states, an assignment of all of the RTC's, that's the Resolution Trust Corporation as a predecessor, all of the RTC's rights and interests in the mortgage and related collateral. The assignment of mortgage makes no mention of or attempt to assign to Lennar, that's the downstream holder, assign to Lennar any cause of action held by RTC. In order for Lennar to pursue an action based on a cause of action held by RTC, Lennar must allege a valid assignment of that cause of action from the RTC. Lennar has failed to allege, and the exhibits attached to the amended complaint do not demonstrate, that the assignment from RTC gave Lennar any right to prosecute any cause of action previously held by the RTC. Since Lennar's amended complaint fails to allege a cause of action upon which, I skipped some language there, but I think you get the point, which is that we have an assignment of a note, and that's all that is assigned. You have an assignment of the rights and obligations under the note, and that's it. We don't have an assignment of the tort claims. There seemed to be some confusion before about whether or not the owner of the property or the initial lender had assigned his claims, but I think the point, whether it was the owner of the property or the lender, they presumably would still have these claims. And I think that's a good point. So, the problem with the relief that's being requested here is that without an assignment from the original lender, my clients could presumably still get sued by that original lender and get sued twice on the same cause of action. That's why you need a separate assignment. And so that's the basis for the motion for summary judgment. Until they demonstrate that they've got that, they don't have a claim. Okay, so that was the point in terms of addressing whether or not the cause of action is brought in their own capacity or as an assignee. And I think based on what's been demonstrated in the record, they don't have a claim either way. If they're trying to sue in their own capacity as a damaged party, they can't demonstrate reliance because the note was obtained after the lawsuit was filed and they already had the field review report at that point in time. All of this is admitted. If they're trying to sue as an assignee based on this Ginsburg case I just read to you, I won't waste your time going through it again, I think that precludes them from suing in tort as an assignee of the note. Those are the only prepared statements I have. We'd ask the court to affirm. Thank you.
May I, Judge? Your Honors, the field review report is obviously done to compare what the actual value of the property is. So for them to rely upon and say, oh, well, you guys should have relied on that report, we're not doing it for that purpose. We want to see what the actual value of the property is. And then we see that their client has $1.3 million and the actual value of the property is so low.
When was the field report done?
Judge, that was done, I believe, in I don't have the actual date with me. I can supply that.
Before you bought the note and mortgage?
No. That's not my understanding. Because otherwise, we buy in bulk. And again, Judge, that is done in the normal course of business. And just for, just as a side, the government has sued a lot of appraisals. Buy in bulk.
There's no way that your company directly and individually is relying upon an appraisal. Because
Judge, again, we are drawing...
It has to be assigned rights that you're suing on as compared to rights in your own right.
True. And if the assignment is an issue, then that's a disputed material fact. And that, again, does not allow a trial court to enter a motion of summary judgment. Because if they're claiming that we don't have the standing from Mr. Dyer, or they also claim that we should have got all the documents from National City Bank, that was the original owner, Judge, that's a very excessive burden, but we provided enough documents to actually overcome the motion for summary judgment. That's the point I want to make today, that if you look at the second DCA's own understanding, own rulings on what the standard is, it's just a slight, if there's a slight, even a slight chance that there is any material fact in dispute, then they must be overturned.
If there's a factual dispute,
Yeah.
this would be reversed. I think we're still worrying about whether or not there's a legal theory here that is alleged or conceivably can be within these facts that you can fly on.
Judge, they rely on the Ginsburg case. The Ginsburg case, if you read it closely, is so distinguishable. It is about a civil theft and conversion based on rental, the transfer of rental rights to receive rents. It has nothing to do with professional negligence on which $350,000 were given by a bank to the lender, and the bank is out of that money. So,
does your complaint allege? Did you pay a specific amount for this particular note?
we don't, Judge, it doesn't allege that. No, it doesn't allege that we paid X amount. But obviously, if I buy, Judge, if you have a car and its value's low, but I want to buy it and I want to fix it and sell it, I can do that. So I can buy that's capitalism. I can buy a note for pennies on the dollar and then figure out what I can do with it. And those are the rights that go along with any standing note or contract.
And so are you claiming that the appraisal is, what I'm pointing out is that you bought at a discount. And I get the impression that from your allegations that you're trying to get the damages that might have accrued for a prior owner of this note or the original owner of the home, but not damages that relate to your discounted purchase.
But Judge, again, that is how a capitalist system works. I can buy on a discount and add value to that contract. I don't think there's anything illegal and ethical about it. One of the things they've been raising...
They're not your damages. The damages you're talking about belong to somebody that's upstream from you.
But I have bought that,
That bought at higher prices.
Yes, sir, but my client has bought those damages because they can't pursue those litigation. Judge, if I may, before I sit down, the government...
You got 30 seconds.
30 seconds. The government has pursued many appraisers. They bought a lot of loans in 2008, which when people went, belly up in foreclosure market, and the government interceded. They bought a lot of these loans and then went after the appraisers. So if we're doing something wrong, as they allege, they try to, defame my client all over the MSJ. Talk about how we are debt collection. We have been.
Give me a cite to a government case where the government as using some governmental entity to do what you're doing here?
Judge, I will provide you that supplemental report. The FDIC has, my understanding is, has gone after appraisers on some of these because they got undervalued too. They bought these loans and they got some, maybe you can ask the gentleman, he may be more aware of that, but I will provide you some citation to that. That's not a problem, Judge. But may I just end with this?
Your 30 seconds is up.
Okay, sir. Thank you. Thank you for your time.
We're going to take a break for about 10 minutes, and when we come back, we'll pick up with Next Gen versus Citizens Property.
Allison, deferred action. Yes, Department of Justice, give you an extra 7 minutes now.